All right. Can we go on to this main event thing then?
I guess so, but I hope I'm wrong, but I don't see a veto being on the horizon. I think he will sign this, and in fact, I would predict he would sign it with fanfare and have press and announce how that he's holding people accountable and protecting the children. That's what I would anticipate.
Of course. All right. Well, you put in this case from the U.S. District Court of the Middle District of Louisiana. The name of the case is Archie Williams, the City of Baton Rouge et al. What does et al. And that's ETAL. So I'll just say et al. What does that mean?
Well, it means rather than naming all the parties, it just means and others. It's one of those Latin terms. I think I've got it right, but Chance can correct me if I'm not right. But that's what I recall.
Correct, correct, correct,
They use that in
correct.
scientific papers too, by the way. They'll name one publisher or whatever researcher, and then they say et al. Like that.
Yeah,
Um,
it
go.
should be versus. Let me put that in here for the transcript. So
I'm sure
okay.
he would correct that and send you nasty grams about it too. He's not in here, so we can talk bad about him. And what's this case about?
Well, the plaintiff is named Archie Williams, was wrongly convicted of rape in 1985, and he spent 35 years in prison for a crime he did not commit.
Now, how do you know he did not commit it?
Well, I'm going by what the evidence has shown in the decades
I
since
see.
he was convicted.
Oh, okay. Well, okay. Well, let me set it up then. So on December 9th of 1982, a white woman was raped and stabbed multiple times in her Baton Rouge residence as she shared which she shared with her husband and two children. The assailant was described as, of course, a black man who acted alone. The man forcibly entered the house and took the woman to a second-story bedroom. The woman recognized him immediately as someone who had come to her back door around a month earlier saying he was lost. She was face to face with him multiple times during the incident. During the assault, the woman noticed a 3-inch long scar on the attacker's right arm. Following the assault, the victim was treated at Baton Rouge General Hospital. At the hospital, police officers arrived and worked the victim to create a picture of the assailant. This doesn't sound good at all.
No, it's not good. And in this case, I don't believe this is going to be anything paralleling last week of false accusations. I believe this woman was viciously raped, and this is legit. But while still in the hospital, officers began bringing photo lineups for the victim to look at. Officers continued bringing lineups to the victim when she was released from the hospital. In one of those lineups, the victim identified the individual who she thought strongly resembled the man who had attacked her. But the man in the photo had different hair. The police brought a different photo, this time in profile, but the hair of the man in the photo was still not right. Finally, officers brought her a lineup, and she jumped out of the chair screaming, "That's the one." I'd like to ask Chance, Mr. Oberstein, who's been doing this for 34 years, more familiar with lineups than I am, if he sees anything wrong with the investigation up to that particular point.
Heck yes. But before I respond, I'd like to note that the woman testified at the trial. She related that after seeing the photo, and she said it was the best feeling in the world to know that there wasn't any doubt left in her mind. She did not hesitate in any fashion when identifying the man. 2 days later, the woman went to a physical lineup where she saw him instantly. The man she identified was plaintiff Archie Williams, and she identified him in open court at trial. Following her open court identification, plaintiff stood before the jury to reveal a scar on his right arm. The victim identified the scar as the one she saw on the arm of the man who raped her. She seemed certain nonetheless.
What do you see wrong with the process up to that point? I mean, I've never witnessed a lineup, so I know I've had seminars, I've attended CLEs on how to properly do them, but did the police follow reasonable protocols up to this point with
It
their
looks
with
like it was I want to interject here for just a second. It looks like they used a hybrid protocol that was highly suggestive. How's
Sure.
that?
I've heard a lot of podcasts talking about this, that the people doing the lineup need to not be the police officers that are investigating. That way they have no sense of how to influence the witness on, are you sure it's not the guy behind door number 4? Are you sure that's not the guy? They have to be completely removed from it, so it's like a double blind study that scientists would use.
So, well, in this particular case, lineups are always problematic because the police wouldn't bring someone that wasn't a suspect. I mean, they're generally not going to put the bank executives and the city councilors and stuff like that in the lineup, and
Right.
they're probably not going to bring those type of, not going to bring a picture of Donald Trump or Joe Biden. So when they're giving these photo arrays, Chance, what do we have to be on the lookout for as a general proposition when a person is being either provided a mugshot book or if they're asked to identify in a lineup? What are the things that stand out that we should be on guard against?
Well, it's using the same photo over and over with a different mixture of people so that it suggests that that's the one. That's the main thing. And that's what often happens. You show a person 6 packs of photos, one person is consistent, all the rest are inconsistent, then you show them a single picture and then another picture, and before you know it, they've identified the person who's consistent in the lineup and in the picture. That's the suggestive part of it. And so then they're married to this identification and believe wholeheartedly and sincerely that that's the one.
Well, she did seem certain, and the jury deemed her credible. At least it would seem so since they convicted Mr. Williams. Williams was convicted April 21st, 1983, and sentenced to 30 years for aggravated burglary, 50 years for attempted murder, and life in prison for aggravated rape. Yet no physical evidence connected him to the crimes. For 36 years, Williams has maintained his innocence. In 2019, he was released from prison when latent fingerprint evidence recovered at the crime scene, examined using a fingerprint database created in 2014, and a different individual was identified as the attacker. Now, Andy, I know you're not going to admit this, but this is funny. 35 years later, after languishing in prison, they figure
Not
out,
not not funny.
okay, if you say so.
I'm assuming that Mr. Williams filed this action after his release.
Correct. He got released in 2019. On March 17, 2020, Williams filed the lawsuit against the city of Baton Rouge and numerous officials for alleged misconduct in the investigation and the prosecution of his criminal case for which he was convicted. Specifically relevant here, Williams alleged 14th Amendment violations under 42 U.S.C. 1983, which is the civil rights mechanism to seek redress, against defendants Lane and Gaydry for failure to disclose exculpatory crime scene evidence, fabrication of crime scene evidence, and conducting a reckless investigation, and against defendant Miller for fabrication of whatever that word is, evidence.
Serological evidence? What is serological evidence? What is that?
I have no idea. That's why we have a lawyer here.
I bet you.
I'm
I
not
bet
sure
you Chance
that's a
doesn't
legal
know.
term, but it's.
Oh, okay. It's
I'd have to look that up.
Serological is testing the blood type to determine if you previously had the virus and may have developed antibodies.
So,
it's a medical term.
And failure to disclose exculpatory serological evidence, as well as state law claims for malicious prosecution, spoliation of evidence, intentional infliction of emotional distress, and negligence against all defendants. So he threw the kitchen sink up there.
But you say you don't like the kitchen sink. This all sounds totally legit of what he would do. Don't you think?
It does.
All right. Well, here it comes, though. Williams moved, for summary judgment on his claims against the defendant Lane, and the forensic defendants moved for summary judgment on plaintiff's claims, asserting qualified immunity. Both motions were opposed, in part. The plaintiff failed to respond to defendant Gaydry's assertion of qualified immunity. Why would he have failed to respond?
Yeah. I wish I knew. It's not really my wheelhouse, but it seems he would have to get over that hurdle in order to succeed.
Do you think that we can go over the summary judgment, the standard for summary judgment then?
We can, yes. We'll go directly from the court opinion. Yes.
All right.
So the summary judgment standard is well set. To prevail, defendants must show, meaning that to prevail, defendants must show that there is no genuine dispute as to any material fact, and they're entitled to a judgment as a matter of law, and that's Federal Rules of Civil Procedure 56A. In making this assessment, the court must view all evidence and make all reasonable inferences in the light most favorable to the plaintiff, the non-moving party. Even so, under federal and local rules, plaintiff must counter with evidence to support his claims. A non-movement will not avoid summary judgment by presenting speculation, improbable inferences, or unsubstantiated assertions. And that's Jones versus United States, 936 Federal 3rd, 318 Fifth Circuit from 2019. That's the precedent that they're using to guide them, the trial judge here.
And then Williams alleged that Lane suppressed a crime scene photograph of a bloody palm print in violation of his 14th Amendment right to due process. In Brady versus Maryland, the Supreme Court held that suppression by the prosecution of evidence favorable to an accused violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. This is well-settled law, is it not?
Oh, yes, it is. It's the prosecutor's duty to provide favorable evidence, and that includes impeachment evidence and exculpatory evidence, and that's United States versus Bagley. You can find that at 473 U.S. 667, 676, and it's a 1985 case. The prosecutor's duty to disclose evidence includes both evidence in its own possession and any other favorable evidence known to others acting on the government's behalf in the case. And you can find that in Kyles versus Whitley. That's at 514 U.S. 419 at page 437. That's a 1995 case, by the way. And the duty to disclose such evidence is applicable even though there has not been a request by the accused. It has to happen automatically.
So what is required to prevail on a Brady claim?
Well, to prevail on a Brady claim, a petitioner must show 1, the prosecutor suppressed the evidence, 2, the evidence is favorable to the defense, and 3, the evidence is material to guilt or punishment. And I'm taking that from Miller v. Dretke, which is 431 F. 3rd, 241 at page 245. And that's a Fifth Circuit case that was settled in 2005. And that is citing Brady at 373 U.S. at page 87. Evidence is material only if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine the confidence in the outcome. And that's Bagley, 473 U.S. at page 682.
The order states, the question is not whether the defendant would more likely than not have received a different verdict with the evidence, or whether after discounting the inculpatory evidence in light of the undisclosed evidence, there would not have been enough left to convict. Would, Chance, can you seriously, dumb that down? That's a lot of weird words and lawyer double speak and twisted back around. Can you dumb that down for me?
Well, let me give it a shot. I mean, to succeed on a Brady claim, a defendant must show that the favorable evidence could reasonably be taken out to put the whole case in a different light as to undermine the confidence in the verdict. In other words, that the verdict wasn't correct. And that's Kyles v. Whitley. That's 514 U.S. 419 at 435. The Supreme Court held in Kyles, that Kyles was entitled to a new trial because the cumulative effect of the suppressed evidence raised a reasonable probability that the jury would have reached a different result. And I think that's where the rubber meets the road in Brady.
But then how did the jury convict him?
Well, because they agreed on the
right? Sure. They all said guilty, right?
So, but because it was made clear to the jury that no fingerprint evidence,
You've been listening to F,
blood connected
Y,
him to the crime.
P.
In opening arguments, the prosecutor acknowledged that, quote, none of the fingerprints taken from the scene matched the defendant, and admitted that there were 2 fingerprints taken from the scene that didn't match anybody. Likewise, defense counsel in his opening statement asked the jury to pay close attention to those fingerprints because none of those fingerprints are plaintiff's. None. At closing argument, defense counsel referred repeatedly to the fingerprints on the blood that did not belong to to the plaintiff, Mr. Williams. Williams' conviction appears to have been based entirely on the tragically mistaken testimony of the victim herself, because the evidence shows that the jury knew the prints in the blood did not connect the dots to Mr. Williams, but they convicted him anyway. So that has to mean that they trusted her eyewitness account. And we've learned in the decades since then that eyewitness testimony is not all that reliable.
Not even close. She had a super traumatic experience, and for right or wrong, it was someone of a different ethnicity than her. And then so she had encountered the dude prior, and she put the two pieces together because they all look alike. And I'm not saying that, but that's what a lot of people would then say. This is so maddening. If I was on that jury, there's no freaking way possible that I would have found that dude guilty if all of that stuff was not matching up. The eyewitness testimony would corroborate the physical evidence. It wouldn't be the only thing required to knock the guy out.
But
All
you're saying that in 2024. What would you have said in 1983 when we had such limited knowledge of forensics and we didn't rely heavily on forensics back then? Do you think you would have said, with an eyewitness sitting there in 1983, he done it? I can, and plus that scar being on, what would be the chance of a person would have a scar? Do you think you would have had the same attitude in 1983 that you have now?
I can only speak to that. I sat on jury in 2003, something like that. And I realized that that's still 20 something years difference. But we had the eyewitness testimony of the DEA guy. And she said that he took pictures of me and used those for extortion so that I would be an informant, whatever it was all that was going on. And we said, great, we believe you, but there's not a picture. So if you have the picture, then we can go along and say that the guy did it. But we had to say that he didn't do it because there was no physical evidence.
So,
but
well,
let's continue.
I would love to believe that racism didn't play a part in it. I hold those idealistic beliefs in our system when people raise their hand and say that they're going to administer justice without regard to that. When you lose that faith that people will take their oath of a juror, and I've made that oath. I've pledged that oath myself 2.5 years ago on the grand jury. I took it seriously. I like to believe that most people do take it seriously, but maybe they didn't.
Not in Louisiana, and still not today, man. Come on. Not Louisiana. Well, let's go into defendant Guidry's claim of qualified immunity. Williams alleged that Guidry should have performed an exclusion analysis on S12, the bloody fingerprint. He failed to contest Guidry's assertion of qualified immunity. How did the court resolve that particular aspect?
Well, not very favorably. The court stated, quote, a party waives an issue by failing to brief it. They cited United States versus Martinez, 263 Federal 3rd at 436, Fifth Circuit. Moreover, local rules require that parties support their arguments with a concise statement of reasons and citations of authorities, and that's Middle District of Louisiana Local Rule 7D. And this court has repeatedly admonished that it will not speculate on arguments that have not been advanced or attempt to develop arguments on a party's behalf. Remember, they're supposed to be neutral, judges are. For this reason, Guidry is entitled to qualified immunity. So he abandoned the argument by failing to brief it. That's the way I read it. I don't know if Chance reads it differently, but I see that he abandoned the claim by not briefing it.
Chance?
Now, I agree with that. That's one of the things I think I mentioned before was if it's, that's a hurdle I think you've got to address. And, because it wasn't addressed, shouldn't be a total disaster. It shouldn't be a miscarriage of justice, but apparently here it is.
So what's next for Mr. Williams?
Well, he's got a couple of options. He can look for a new vehicle, or he can file an appeal to the Fifth Circuit, where this would go. But appealing this 1983 claim, these processes are largely well-defined in terms of what he would be appealing. I would expect limited or no traction if he were to appeal in the Fifth Circuit. So he has to find another vehicle and see if there's a recovery mechanism that exists, or he's got to convince the Louisiana legislature to change the law. Now, I know that Governor Landry, being a former prosecutor, and I know that all those conservatives that run the legislature, I know in my heart that they would want a miscarriage of justice to be compensated, and I know that they would quickly pass legislation immediately if they were asked to do so. Do you agree with that, Chance?
No.
You don't agree with that?
So.
You don't. Would you agree with the part that he's got to find another vehicle or he's doomed?
Yeah, I think so. Yes.
So,
And just to reiterate, 1983, that's not the year. That is a civil rights claim?
yes, it's a section of U.S. code
Okay.
that allows you to seek redress, but it's very limited in terms of you have to jump through a lot of hurdles to show that the right that it was violated was clearly established, that it was deliberate, not a good faith mistake, and it's really hard to prevail on a 1983 action. But people do prevail.
And so the guy spends 36, is that what it was? 36 years in prison? And no one can see that his civil rights were violated?
Well, no, they can see that they were violated, but the vehicle he's using doesn't permit him to recover because these people are immune. And he waived immunity for the one that might have had some liability because he didn't brief it. It sounds like some bad lawyering, but I don't want to say it's bad lawyering because we've got a lawyer on the panel, and it may be bad lawyering, and there may be some strategic reason that he made that decision to abandon, but I can't imagine what that reason would have been.
Yeah, I can't either.
Does this then mean that they open the doors, let it out, and say, sorry, and there's nothing for him? There's no monetary, I'm sorry, 36 years are gone. Sorry, sucks to be you.
Well, Louisiana could have its own compensation scheme for improper incarceration, and some states do, and you would file the claim like it might be in a state might have it $50,000 a year or some arbitrary number for years of wrongful incarceration. But this one is going to be a little bit dicier because I would say there was if I were sitting as a judicial officer, I would not see malicious misconduct here. We've got to look at this through the technology that existed at the time. We can't look at it through today's technology. So we've got to pretend we got to set up a trial in 1983, and we've got to look at the type of evidence that would have been available in a trial in 1983. And when we look at what evidence would have been available, they would have only had the evidence that they looked at. They would have not, if there was no fingerprint that matched anybody, then all they would have had was her evidence, her testimony. What were they supposed to do? Say, well, we're going to dismiss the charges because we don't have a fingerprint match. They would not do that. So I don't think there's anything malicious or willful about this. I believe that they thought that they had the right guy.
I cannot imagine, Larry, that Louisiana in 1983 would have a white victim and a black defendant, and that they say, "Oh no, he didn't do it." Louisiana is, I'm gonna catch hell for this, is one of the most racist states today, and it has not gotten better than what it was.
Well, I would say there are plenty of racists in Louisiana and Alabama and places like that, but if you believe that every prosecution that took place in 1983 was devoid of any consideration for the facts as we would have understood those facts in 1983 were very compelling at the time. You make the mistake of wanting to look at it through the evidence we have today. We have forensics today that have identified something they could not examine to a conclusory standard in 1983, and they've concluded that he was not the person. But in 1983, they thought he was the person because he had the scar, he had the eyewitness identification, and so it was a compelling case at that time.
Very well. California Corner, Chance, are you ready?
I am ready.
You've been listening to FYP.